Hello, everybody. Welcome to another episode of the Visto Show. It is Friday, of course, August the 23rd. I had to take a look down. August has just flown by. August the 23rd, 2024. How the heck are you? Welcome to another episode of the Visto Show. We got an exciting one today. As always, some spicy express entry updates and news. As always, a new pilot program. What do you know? Another day, another pilot program. What can I say? And I have some strong opinions on that, but we're going to talk about the details. We're going to go over it. We're going to share our thoughts, opinions, all that fun stuff. And then a quick mention on the federal court, especially as it relates to litigation and AI in preparing documents. So if you're at all interested in that topic, we'll do a quick segment on that. And then what we're going to do is we'll do a quick update on Visto, as well as taking some immigration questions with our AI Copilot. So I've gotten a few really good Canadian immigration questions ahead of time from you folks. So thank you very much for those of you who submitted questions. If you do have Canadian immigration questions and you want to see our AI answer the questions live on air, then make sure to say hello in the chat, send your question, send a comment, anything like that, and we will save that for the end of the show. So without further ado, I'm going to dive in to topic number one. And that topic is the gift that keeps on and always is giving is express entry. Because it's been another, I would say, interesting month. I'm going to put the link to this in the comments as always if you want to follow along. If you are watching live on LinkedIn, thank you very much for tuning in. And I'm going to be putting these links in the comments if you'd like to open them up as well. If you're watching after the fact on YouTube, well, number one, you're missing out live on LinkedIn, which I highly recommend doing because then you can tune in and take part of the conversation. But I will have these links in the description below if you're watching after the fact on YouTube as well. So number one, let's talk about express entry. Now it's nearing the end of August, but as you can see, we've only had 3 draws in the month of August. Now, not necessarily that odd or off, but there's a reason for that, right? And part of that reasoning is, as most of us know, express entry draws typically happen every 2 weeks. And it just so happened that last month in July, the draws happened on the last days of the month, which means that we're probably not going to see the first draws of August until the second or third week of the month, right? Which is exactly what happened. So what happened was, on August 13th, 14th, and 15th, as you can see here, Immigration Canada did 3 consecutive draws. They did their patented PNP draw on the 13th, inviting 763 people to apply. They then did a bigger CEC draw, inviting 3,200 people to apply. And then they did a French language proficiency draw, which has quickly become one of the more popular draws from IRCC, inviting 2,000 people to apply. Doug says another day, another pilot. I know, Doug. I mean, you know, right? I don't have to tell you a bigger. Oops, let me put that on pause. I don't have to tell folks like you that are keeping a very close eye on Canadian immigration that not too much of a surprise. But we're going to get to that topic in just a minute. So what I'm noticing with express entry here is that we're getting into a little bit of a theme. I'd say the last 2 years of express entry have been pretty tough to guesstimate in terms of like what's coming next. But the last few months, you can see here, we've kind of got into a bit of a pattern. Number one, a big item that I'll point out is that IRCC has moved away from all program or general draws, right? They were doing general draws for the first quarter of 2024 through April. So I guess a little bit more than the first quarter. But ever since April, we have not seen a single all-program draw. So this is important to keep in mind, especially if you're an immigration professional, obviously, and or if you're an aspiring immigrant outside of Canada. Why do I say that? Because if you're outside of Canada, you definitely don't have any chance at a Canadian experience class invite, unless you've been to Canada for at least a year and then left. You probably have a harder time getting an invite through the PNP stream because a lot of the PNPs, require some sort of connection to Canada. And well, maybe you speak French, so I shouldn't say that. But when they stop doing these all program draws, it certainly makes it a little bit more difficult for those folks who are outside of Canada. So as you can see from the last few months, we're starting to notice some trends. IRCC doing a lot of CEC draws, right? So you can see a lot of them here, and they're pretty big: 3,200, 5,000, 6,300, 3,000. So some of the biggest draws, consistently big draws that we're seeing are CEC. They're starting to do a lot of PNP draws, but they're not huge draws, right? So you can see 763 people, 964 people, 1,300 people, and that's just because there typically aren't as many people getting CEC PNP nominations on average, right? It's easier to meet the CEC requirements than it is to get a PNP approval, right? So just something to keep in mind. And then we're seeing a mishmash of industry-specific draws that, as you can see, are largely prioritizing French language proficiency. So we can see here there was a French draw. In July there was a French draw. In July there were 2 French draws. There was a healthcare, trades. Here's another French. Here's a STEM. Here's another French. Here's a transport. So they're doing like almost every second industry-specific draw is for French speaking. Now that'll be an interesting segue into our second topic, but basically, if you want to come to Canada through express entry these days, you kind of need either to be eligible through CEC, or to get a PNP nomination, or to be eligible through one of the industry-specific draws, preferably the French-speaking one, right? If we're looking at historic numbers and stuff like that. So anyways, let me know what you think. Any questions, any comments? What are your thoughts on how things have been going with express entry? It's certainly been interesting to follow. They certainly keep us on our toes, and we will continue to monitor and see how that goes as well. So, quick patented segue sip. We're going to jump into the next topic because I don't have a ton of time today, so I'm going to move at a relatively efficient pace here, and we're going to talk about another pilot program. I joked about it at the beginning of the show, but yes, yours truly thinks that IRCC is doing way too many pilot programs. I've said it many times before on the Visto show. I'm going to put this link in the comments as well if you want to follow along. This is an announcement or a news release from IRCC dated August 14th, so about a week and a half ago now, where IRCC is launching a pilot program in August in partnership with designated French language and bilingual post-secondary DLIs. Minister Miller also announced the addition of 10 communities to the Welcoming Francophone Communities Initiative and Students in Francophone Minority Communities pilot program. Canada recognized, blah, blah, blah. The pilot program is a flagship measure of the policy on Francophone immigration and will benefit FCMCs by helping them attract and retain international students. Funny, I thought we were trying to limit them. To improve the approval rate, students and their families will be exempted from having to demonstrate that they will leave Canada at the end of their temporary stay. In addition, the required financial threshold will be adjusted to reflect 75% of the low-income cutoff associated with the municipality where the institution's main campus is located. Okay, so they're basically, switching up a bunch of these standard study permit requirements. So for any temporary residence application, study permit, work permit, visitor visa, one of the key factors you have to show is demonstrating that you'll leave Canada at the end of your stay. Now, one could argue that that is a pretty stupid requirement to begin with, because international students, most of them, do plan on staying, right, through programs that Canada has created, such as the postgrad work permit application and the CEC, express entry route that kind of like gets people into the lane of, right? So in my opinion, the demonstration that you'll leave Canada at the end of your stay, that needs to be rejigged anyways for international students, at least in some cases. If you're going to have all these programs that allow and promote them staying and eventually getting PR, maybe this shouldn't be a determining factor for the study permit to begin with. But anyways, for French speakers who want to come as students, this will be waived, and they're going to get a 25% reduction in the effectively proof of funds, right? So with a study permit application, with many applications, we have what are called a proof of funds requirement, so showing that you can afford to make this travel to Canada and study and support yourself. And that will be reduced in this case. Pilot program participants will also benefit from a direct pathway from TR to PR after obtaining their diploma, and they will have access to settlement services, etc., etc. With their proficiency in French, graduates will be able to contribute to the Canadian labor market and enrich FMCs across the country. Although an annual cap for most study permit applications was established in January, this is not included in the cap. So hey, let's make a big cap on international students and then start launching programs that are exempt from this cap. Doesn't make too much sense to me, but maybe I'm missing something here. Each participating DLI will be allocated a limited number of acceptance letters that can be issued for the purpose of processing study permits. The maximum number of study permit applications will accept under the pilot program is 2,300 for the first year. Okay, so it's not a huge number, 2,300 in the grand scheme of things. For most who don't know, there's going to be somewhere in the range of like 300 plus thousand study permits approved this year, probably more, maybe closer to like 400,000 study permits approved this year. So 2,300 in the grand scheme of things, not a huge amount. A cap for the second year of the pilot program will be set by August 2025. And then they go on to mention the different communities that have been welcomed, and I'm not going to spend time on it because it's, you can read through this if you'd like. Not hugely important for the purposes of this conversation. Now, if you have any if you have any opinions or thoughts, I'm always happy to hear them. So here's another important quick fact. The participants of this pilot program are not bound to provide a provincial attestation letter or territorial attestation letter with their study permit application. So again, this was a change that was made in January, was that the government was going to limit international students for the next 2 years, and attestation letters are going to be a new document requirement for that process. Those have been waived for this new pilot program, and it'll be interesting to see, how this all plays out. Now, what are my thoughts? Good question. I don't know. We just talked about all these crazy French language proficiency draws and express entry, so it's just very clear that the government is putting French speakers above most other things, right? So for example, they're not making any special exemptions for healthcare workers or blah, blah, blah. They're prioritizing French-speaking international students. They're prioritizing French speakers for express entry. I've had this conversation before on the show. I don't necessarily want to go into full detail again, but I question whether this should be, do we need more French speakers in Canada? Probably. Should French speakers be given this much crazy priority in all levels of our immigration? I don't know, right? I don't know the numbers. I don't know how badly these communities need more French-speaking workers. I've lived in Ottawa. I live now in Toronto. I see and hear barely any French. So especially for something like express entry, which is for people not living in Quebec, how much of this French speaking is actually needed? Again, I'm sure there's some. I'm not doubting that I'm sure there's some, especially for government workers. But should they be prioritized this much, or is this just like a political move to keep people in Quebec happy? I don't know, right? If you have any thoughts, opinions, I'm always curious to hear those, so feel free. Now, on a semi-related note, I think the bigger problem is that it's just another pilot program. And the problem that most people, especially if you're not an immigration professional and you haven't dealt with IRCC much, IRCC does not need to be spending more time, energy, and resources creating new programs. They have enough programs and they can't even process those properly. So as they keep stacking, let me explain it this way with a quick visual, because visuals, picture paints 1,000 words, whatever the heck it is, right? If you're IRCC, this is IRCC, let's just say processing center. Let's just pretend they have one processing center, which they don't, right? They have many processing centers. And let's say you have one application, right? You have a work permit. And all this processing center has to do is process work permits. That's really easy because it's one application, it's one standard process, it's one document checklist. Now, a few items on the document checklist can change from client to client and application to application. but it's relatively easy to process that one application, right? Now, let's add in a few more, right? So we have the TRV, we have the study permit, right? Getting a little bit more confusing. And this is just temporary residence. Now let's look at permanent residence. Let's look at express entry. Let's look at spousal sponsorship. Let's look at the SUV, right? Startup visa. Let's look at H&C, right? And I'm just listing some of the very basic applications, right? Let's keep moving down the pile. We need our now PR card renewals, right? We need citizenship, right? So you get my point. I'm adding more and more of these. And this isn't even covering everything, right? There's refugees. There's port of entry stuff, right? There's, family class, right? I mean, spousal sponsorship's under the family class, but you get my point. My point here being, as you add more and more of these application types, you have more and more document checklists, processes, resources and people that you need to train in order to process them, and it gets more and more complicated, right? Day by day. So, the reason why I say this is because they are already behind and slow on doing all of this and more. So what happens is when you start adding in more and more, let's just call it Pilot A, and then a month later they start adding in Pilot B, and then a few months later they start adding in Pilot C, and this has basically been happening like all since COVID, right? All these exemptions and new pilot programs and stuff like that. So you still have the same amount of processing centers. I'm sure they add more here and there. You still have, you're hiring new staff. They've had to hire new staff. But you might have the same budget. You might have the same amount of processing centers. You might have a few more people. But now you have to have new processes and systems and standards and training and learning for every single one of these applications. And you're adding new ones every other month, it feels like. And this is part of the reason why this processing has been, delayed, late, poor decision making, right? So I'm hearing from lawyers and consultants from across the country that the decisions that we're now getting from IRCC are kind of as unpredictable as ever, if that makes sense, right? So anyways, this is my take. It's just one person's take on why we don't need more pilot programs. We need fewer, actually. And I think that would actually make things even better. Doug tunes in. He said, I received a refusal for a 6-month-old baby. Reasons: not enough assets and insufficient funds. What a joke. It was the same finance and assets I used to get a visa for baby parents and siblings earlier. Well, Doug, clearly the 6-month-old baby has not been working hard enough and saving properly, right? There are so many immigration professionals, but IRCC is not hiring them, even on contract basis, to clear up the backlog. Yeah, I mean, like I said, Doug, and then the other problem is, not only are they not doing that, but they continue adding in new pilots, right? So not only are they already behind and not catching up, but they're spending resources that could be spent on catching up and clearing the backlog, and instead they're using resources to create new pilot programs, right? And these pilot programs are supposed to be prioritized. Yeah, and so they get pushed to the top. So even though you might have applied for one of the standard applications 6 months ago, they create this new random pilot program, and now these people get pushed to the top of the pile, right? Pardon my terrible drawing here. So it's I think it's a mess. I think the whole system needs a cleanup. The first thing I would do if I were, this probably would never happen, but the first thing I would do on day one as immigration minister would be to scrap every pilot, and every non-permanent program would get scrapped. Day one, no questions asked. Wipe out all the pilots, just give them the cut, and start reprioritizing and catching up on what you have in inventory for the most important, most popular, most core programs to Canadian immigration. Build back efficiency and streamlined processing times and good decision making and all that fun stuff. So anyways, again, pardon my terrible drawing, but yeah, I just wanted to get that message across. Sounds like Doug's on the same page. I've definitely heard from many consultants and lawyers that are thinking and saying the same thing. I don't want to speak on behalf of everybody, but there seems to be a lot of agreement there. Okay, lastly but not leastly, before we get into our quick Q&A here, I want to talk about the federal court. Now, this isn't necessarily new news, but we are covering it now because Visto, as many of you know, Visto is a platform that helps Canadian immigration law firms prepare documents, prepare applications, manage clients, manage files, all that stuff way faster. And over the last few months, we've made our AI a whole lot better. And we've been adding things like case law. We're working on adding case law into our AI as well, which will go live shortly. And so what we've done is gone through and scoped out, for example, in December, the Federal Court of Canada came out with a notice, and I'm going to put a link to this blog post again in the chat or in the description if you're watching on YouTube. And the Federal Court came out with a notice that basically explained what their expectations are if you're planning on using AI to create documents to submit to the Federal Court of Canada for the purposes of litigation, right? So keep in mind, this does not relate to any immigration document. It doesn't relate to, for example, a cover letter you might be submitting to IRCC. This applies to the Federal Court of Canada. And as you'll see here, this notice applies to all documents that are submitted to the court being the Federal Court of Canada, and prepared for the purposes of litigation. So this is primarily for those of you doing litigation at the federal court. For greater clarity, this does not apply to certified tribunal records submitted by tribunals or other third-party decision makers. So if you're not doing litigation in the federal court, this will not apply to your day-to-day. But you might just want to, be apprised because you never know what could happen. Now, what I would say is I'm not going to go through every detail here. Read the blog post if you're interested. You can see it's very short. And then I even linked to the notice. And the notice is pretty short too. It's like 2.5 pages. But probably the most important part of this is the fact that the court is saying if you are going to use AI in any way to prepare, not in any way, in an effort of creating content for the document that you're going to submit in court, you need to declare the fact that you've used AI. So for example, you can see here, any document prepared for the purpose of the litigation and submitted to the court by or on behalf of a party or intervener that contains content created or generated by AI must include the declaration. The declaration shall be made in the first paragraph of the document in question, for instance, the first paragraph of a memorandum of fact and law or written representations. An example of the declaration follows, and you can see here pretty straightforward, just says declaration, artificial intelligence was used to generate content in this document. Now this is somewhat vague, right? Like for example, in our article I talk a little bit more about, what if you didn't use AI to generate the entire document? Maybe you want to say something like artificial intelligence was used to generate paragraphs 3 to 6 in this document, right? You might want to make it a little bit more specific based on how and the different ways that you may or may not have used AI as well. So we wanted to just make this available because this is extremely important, especially as we start improving our AI and making it helpful enough to be used for things like the federal court, case law, judicial reviews, other forms of like litigation and appeals and stuff like that. So hopefully you find it helpful. Like I said, if you're interested, the link to this blog post is in the description or in the LinkedIn comments as well. Lastly, but certainly not leastly, we are going to jump in to a few of the immigration questions. So again, for those who don't know, Visto is an AI platform, AI and automation platform that helps law firms do a whole bunch of stuff, right? You can see all the stuff in the menu items here. For the purposes of this show, we are going to focus on the Visto Copilot, which is a custom-built and trained chatbot specifically for Canadian immigration questions, operational manuals, all that fun stuff. So if you have any immigration questions and want to test them, let me know. So you can see here, you can basically type whatever the heck you want, and the Copilot will answer the question. It'll provide you with sources and stuff like that. So I put this out to the network to see if anybody had Canadian immigration questions that they needed help with, and we did get a few. One question I have is from Rahman. Rahman asks, my 2 diploma course from a DLI ends this month of August, and the graduation credentials will be with me by end of September. I can apply for PGWP the next day itself since my study. Oh my god, this is a long question. Let me just copy and paste it into the Copilot. So I'm going to hit enter here so that Mr. Copilot, Mr. or Mrs. Copilot can start doing some thinking right away. But basically what Rahman is asking is, what's the process of starting to apply for the PGWP and for applying for jobs and stuff like that? So for example, you can see here the Copilot is answering in a quite organized fashion here. Your understanding is partially correct. You can apply for a PGWP as soon as you receive your graduation credentials, given that your study permit is valid until March 2025. However, you are not automatically authorized to start working for a company the next day after applying. You may be authorized to work without a permit pending decision under paragraph 186 if you apply for your PGWP while your study permit is still valid. It is important to ensure that you have applied for the PGWP before you begin working, as working without authorization could negatively impact your status. Yes, you can start applying for jobs before you receive your graduation credentials and before you apply for the PGWP. There's no legal restriction on job searching or attending interviews. However, you cannot begin employment until you have either applied for the PGWP, if eligible to work under R186, or have received your PGWP. So you can apply for jobs, but you can't start working until you get that, either until you get the PGWP approved, or you submit the PGWP and you're eligible to work while waiting for a decision. Before applying for PGWP, can I work remotely for a non-Canadian company? What about remote work for a Canadian company before applying? Please help me clear my above doubts. Before applying for the PGWP, you may work remotely for a non-Canadian company, as this work is not performed within the Canadian labor market and does not require a Canadian work permit. However, working remotely for a Canadian company is not permitted, as this would be considered working within the Canadian labor market. You must wait until you have either applied for the PGWP and are authorized to work, or have received your PGWP. So this is a really interesting question, Rahman. It's a really good question. And this is a pretty good answer, and is what I would have said, but the Copilot says it a little bit more eloquently than I would have, which is basically, you can work remote if the company is not based in Canada and doesn't have a presence in Canada, right? Because the way that IRCC looks at that is, if you're taking a job from another Canadian, or you're working for a company that's in Canada or has a presence in Canada, you need a work permit for that. If you're working remotely for a company that is outside Canada and has no presence in Canada, you can work remotely for them while inside Canada because you're not negatively affecting the Canadian job market. So that's kind of the answer to that there. Hopefully you found it helpful, and thank you very much for submitting your question. Okay, another question. This is, I think it's also from Rahman. And I'm an international student in Canada about to complete my 2-year course and start PGWP. I understood that I'm having ADHD and am planning to start treatment for that here in Canada. Please let me know if this will affect my chances for PR in any way. Thanks. That's an interesting question. I don't know off the top of my head what the answer is. My guess is that it doesn't affect PR, but let's see what the Copilot says. In itself should not directly affect, because usually in terms of like medical stuff, it's like, are you going to be what's the potential effect on the Canadian healthcare system? I don't think ADHD would, be such a negative impact that it would affect immigration, but should not directly affect your eligibility for PR. However, there are certain factors related to health that can impact your application. Under Canada's IRPA, all applicants for permanent residence must undergo a medical. The purpose of this examination is to determine if the applicant has a health condition that could pose a danger to public health or safety, or cause excessive demand on health or social services in Canada. So that's kind of what I was alluding to. ADHD is generally not considered a condition that poses a danger to public health or safety. However, the excessive demand aspect is assessed based on whether the treatment would likely exceed the average cost of health and social services over a period of time. It's important to note that as of June 1, 2018, the definition of excessive demand has changed, and certain applicants are exempt from the excessive demand assessment, such as spouses, common law partners, etc., etc. For economic class applicants, the excessive demand assessment still applies. However, the threshold is reviewed and updated annually. If you're applying for PR and are concerned, you should ensure that you have comprehensive documentation from your healthcare provider regarding your condition and treatment plan. Be prepared to provide this information during your immigration medical examination if required. Understand that each case is assessed individually, and the cost of managing ADHD may not necessarily exceed the threshold. So hopefully this helps, Raman. I think you would be fine, but this obviously depends on a whole bunch of other factors, and also being a case-by-case decision. But hopefully you found that helpful. And of course, thank you for the question. I think there might have been one more question. There were a few more, but it looks like one or two of them was also from Raman reworded, and it was the same questions, which we've already answered. Here's another question from Com. Com, thank you for the question. And Com asks, what happens if my work permit extension is refused while I'm working under maintained status? What options do I have? It's been over 120 days and still no updates from IRCC. Let's see what the Copilot has to say here. If your work permit extension is refused while you are working under maintained status, you must stop working immediately upon receiving the refusal notice. Maintained status allows you to continue working under the conditions of your expired work permit while a decision on your extension is pending. However, the status is no longer valid once a decision is made, and if the decision is a refusal, you lose the legal authorization to work. What options do I have? Regarding the delay, it is not uncommon for processing times to exceed 120 days, especially during periods of high volumes or due to operational challenges. However, if you believe the processing time has been excessive, you can check the status through the website if you haven't already done so. Contact the call center for an update on your application status. Use the web form to inquire about the delay, providing details of your application and the time elapse. If the work permit is refused, you have a few options. Number one, you can leave Canada. Number two, apply for restoration of status if you are within 90 days of the refusal, which you haven't received yet, I don't think. You may apply, hopefully you don't receive one at all. You may apply for restoration of your temporary resident status. This application must include a new work permit application and the reasons for the restoration. Legal remedies. If you believe the decision was an error, you may seek legal remedies such as requesting a judicial review at the Federal Court of Canada. This involves legal complexities and strict timelines, so it is important to act quickly. Reapply. If circumstances have changed or if you address the reasons for refusal, you may consider reapplying for a work permit. Again, obviously, this is very case dependent, case by case. Depending on the reason for refusal, you might want to consider talking to a professional to get more help, but hopefully this answer provides a little bit of help as well to come. And that is it for the questions I received. So thank you very much for everybody who sent in their questions ahead of time. Hopefully you have found them useful. Hopefully you found the show useful. Kind of interesting what's going on now with Express Entry, the new pilot programs, all this kind of stuff. So thank you very much to all those who did tune in live, and of course to all of you who are watching after the fact, whether it be on LinkedIn, on YouTube, wherever the heck it might be. So anyways, thank you again, everybody, for tuning into the show. If you are watching after the fact, if you can give us a like, a comment, let us know what you think. If you have any questions, comments, make sure you're subscribed on YouTube so that you can catch all of the future Visto shows as well as they come out. And definitely make sure you're following me on LinkedIn if you ever want to tune in live. Thanks again, everybody, for tuning in. Hopefully you enjoyed, and I will see you in the next one. Take care.